The recent Shraddha Walker murder case has again ignited this debate. Are there protective laws for the women in the live-in relationship? Recently, we have seen that the younger generation is preferring to live in the live-in relationship and not marriage. So, are there protective laws for the women? Well, a beneficial piece of legislation, which is known by the name the Protection of Women from the Domestic Violence Act, has been there since 2005. As per Section 2, which defines the domestic relationship, it starts as the domestic relationship means a relationship between two persons who live or have lived together in a shared household when they are related with consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. So perhaps the legislature has recognized this form of relationship, which is the relationship in the nature of marriage. In this broad kind of a relationship, the live-in relationship gets covered if it satisfies certain basic parameters which is defined by the Supreme Court. The Supreme Court, in the case of Indra Sarma versus VKV Sarma, 2013, Volume 15, SCC, page 755, it describes certain basic parameters upon the satisfaction of which it would be considered that the live-in relationship would be a relationship in the nature of marriage for getting covered under the Domestic Violence Act. So what are those parameters? Well, the first parameter is the duration of relationship. So if there is some reasonable period of cohabitation between the couple, then that duration would prove that the nature of relationship is in the nature of marriage. Second parameter is the shared household, living in the shared household. Third parameter is pooling of resources and financial arrangements. So if the couples are supporting each other financially, or they have joint bank accounts, or they are buying property in the joint name or in the name of the women, or there is joint venture or business, then it also proves the nature in the nature of marriage. The fourth parameter is domestic arrangement. If there is entrustment of mutual responsibilities among the couple, for example, for cleaning or for quick cooking or for buying the groceries for the house or for maintaining the house, then it also proves the nature in the nature of marriage. The fifth parameter is sexual relationship, which proves the emotional and intimate connect. The sixth parameter is if there is a child, then that by the fact proves that the relationship is in the nature of marriage. The seventh parameter is socialization in the public. So if the couple is holding out to the public at large that they are living as husband and wife, then it is one of the basic parameters which proves the relationship in the nature of marriage. And the last parameter is intention and conduct of the parties, how the parties are conducting, that proves their relationship in the nature of marriage. So if these basic parameters are satisfied, then a live-in relationship would be covered by the Domestic Violence Act, and the women can approach the court for various kind of protection under the law. For example, monetary protection, or the protection from the violence, or for maintenance, or for residential order, and etc. Thank you.